committed the offense of burglary of a habitation in violation of condition number 1. The then and there failed to submit to drug testing as directed by the court. The then and there failed to submit to drug testing. The then and there failed to complete 178 hours of community.
That's when he forced entry. He kicked it, boom, and that's when he took 2 steps in, snatched her by the head, and took her, drug her outside.
Okay. And so you were standing, is it like a hallway? Is it a living room? Like, where were you standing?
Open space. It's my living room, dining room, kitchen. Simple.
Okay. And when you first came out of your room, do you know where Jasmine was?
She was right there on the, like right here in the hallway. It's not like maybe 3-4 steps from the door.
So Jasmine was standing 3-4 steps from the door.
Yeah, and she was talking to him right there in the hallway, right there from my restroom hallway to the door. It's my door, restroom, hallway right here. She's looking, catty corner, looking, and I asked her, I said, what's going on, Jasmine? He says, I got my phone. That's when he forced entry. He was not going by what I said. I'm calling the cops. Get away. My neighbors are here. They're hearing. We don't do that over here. It's a quiet neighborhood where I'm at. Nobody does all that screaming and hollering and my neighbors do call the cops. And I told him, to prevent everything, they had just had a similar situation like 2-3 days before that.
So this is additional information that you're sharing now. As I ask you questions, you didn't share in direct. Do you also remember talking to detectives and police officers on the scene on the day this happened?
Okay.
I'm asking, do you recall that?
Yes, I do.
Okay. And this information, like this additional details, you didn't give him any of that information.
Give them what information? That they had that simple argument days before?
No, you're adding details about.
What details did I add?
About pounding on the window, about these statements that he's saying to her and her talking back to him. Like, those are things that you're saying now that you haven't said before. You didn't say on direct examination. Let's say, correct?
Okay.
And so let me ask again.
So is that just that little piece of additional?
I'm going to object to non-responsive, Judge.
Sustained.
You got to wait for the questions. This is not like you get to say stuff to me. The way the rules work is we ask questions and you have to answer. Okay?
Yes.
So I want to go to the moment that you're saying the door opens. Okay, the door is kicked in per your testimony. Okay, you're in this living room area, this front area with Jasmine, and I assume your kids as well. Is that correct?
Yeah.
Okay. And you said that Jasmine was 3 to 4 steps away from the door. Is that right?
Yes.
Okay. And then it was your testimony that when Alonzo kicks in the door, he took 2 steps in and snatched her.
And reached, grabbed her, snatched her. Yeah.
Okay. You said Jasmine's 3 to 4 steps. Alonzo takes 2.
Do you see how big that guy is? The reach is not that. Reaching. Come on, man.
Okay. So let me ask you this. When you saw the door being kicked in, what was your initial physical response? Like, what did you physically do?
What could I do? 2 people out there with a gun.
Had you seen the guns at this point?
Yes, I did. Okay. Even the kid seen it. The laser was pointed on my daughter's chest.
Before we even hear the judge speak, you need to understand what kind of courtroom moment this is. This is not a misunderstanding. This is not a one-time mistake. This is a case where the court has already shown mercy multiple times and is now openly questioning whether that mercy was wasted. At the center of this case is a young man on deferred adjudication, already standing on thin ice, and a family dynamic that the judge clearly believes is enabling chaos instead of accountability. From drug violations to probation failures, from questionable associations to a violent incident involving forced entry, firearms, and children present, this case touches nearly every red flag the justice system looks for when deciding whether rehabilitation is still possible. And listen carefully to how the judge speaks here. This isn't casual frustration. This is controlled, deliberate warning language. The kind judges use when they're signaling that prison is no longer a threat, it's a probability. The courtroom tension you're about to hear isn't just about guilt or innocence. It's about credibility, responsibility, and whether the system has reached the end of the road with this defendant. As you watch, ask yourself, when someone is given chance after chance, at what point
wasn't that after it had all gone outside?
Yeah, but still, you're sitting here trying to defend something. If it was your children, how would you have felt?
I'm going to object to non-responsive again, Judge.
Sustained.
So you got to. I'm not trying to be you know, I'm not trying to get a rise out of you, okay? But you have to answer my questions, and you're adding additional information that I'm not asking about. Okay, so you just gotta wait for me to finish the question and just listen to the question I'm asking.
It's a heated moment because if you were in that situation, it's bringing you back what happened that day.
Okay. So Miss Heard, okay. When you're in that front area and the door gets kicked in, right? It's okay with whatever the answer is what the answer is. I'm just asking you, what was your physical reaction? What did you physically do?
Physical reaction. I just stood there and let him.
Okay. And at that point in time, what did you see anybody else do besides my client, besides Alonzo?
What do you mean? What did I see happen?
Like,
he drug her outside. The two little boys that were over there by the car, they came around with the gun. They came to my front gate where the door opens. They stood there. I said, I'm going to call the cops. And he put the gun out. My daughter was standing in the doorway. I told her, get out of the way. My nephew happened to run across the beam, hit him. So what else do you want me to explain?
Well, I have a lot I need you to explain. Okay. This is going to go for a little bit. You got to just take a breath. Okay. It's all right. So my question is, would you agree with me that if somebody kicks in a door and you feel threatened by them, that oftentimes someone would either like try to run away, try to push somebody out? Like, did any of that happen?
No, because
okay. So objection non-responsive. Objection non-responsive.
Overruled.
Did that happen? Yes or no?
Yes.
What? They pushed him away or you ran away?
No, I'm telling you, I didn't have no physical anything. I just stood there and let him grab her. What did you want me to do?
I'm asking you a simple question. It's a yes or no.
No.
Okay, thank you. So, and then you say that he starts to bring her outside. And I want to be clear because I don't know if you meant to say this or not. You said on direct that he had a gun, like in reference to Alonzo. But Alonzo, you never saw Alonzo with a gun, ever, correct?
No.
Okay. I want to make sure that's clear. So you never saw Alonzo with a gun. The people you saw with, hold on. The people you saw with guns were the two other individuals, correct?
Yes. I said that.
It was a little unclear to me. I was just trying to clarify. Okay. So you never saw Alonzo with a gun, and your kids never saw, or the kids never saw Alonzo with a gun, correct?
Yeah.
Okay. Now, according to your testimony, Jasmine's being brought outside. Do you and the two kids go outside?
I ran outside.
Okay, you ran outside.
I tried to stop him from dragging her.
Okay, so you outside, and so that's when you see the two individuals that were with Alonzo, allegedly. Okay, and had you recognized those people at all? Like, did you know who they were?
I don't know neither.
Okay.
None of them.
Okay.
How am I going to recognize them?
Well, that's my question. Okay. Now, they were standing, I believe, according to your statement, they were standing like by the street. Is that fair?
Yeah, on the curb by the car. Yeah.
Okay. And so again, as Alonzo, according to your testimony, is taking her to the car, at some point you're saying that after Alonzo's towards the vehicle is when these two individuals point these weapons, correct? Yeah. Okay. But those weapons, as far as you could tell, like you couldn't see exactly what they were, right? Like, okay.
What the judge just laid out is more than a lecture. It's a legal boundary being drawn in real time. Notice how the judge directly addresses the mother, not just the defendant. That's intentional. Courts often recognize that probation success isn't just about the individual, it's about the environment they return to. Here, the judge is explicitly stating that parental enablement can be just as dangerous as criminal behavior itself. The marijuana use, the non-compliance, the girlfriend staying over, the lack of structure, none of this exists in a vacuum. Legally speaking, the judge is making something very clear. Probation is conditional freedom. Every condition violated isn't just a technicality, it's evidence that the court's authority is being ignored. And when the judge says age is just a number, that's a warning shot. Youth will no longer be a shield. At this point, the court isn't asking if consequences are coming.
I'm going to go back just a little bit, okay? I apologize for going out of order. When the kids came into your room to get your attention, do you know where Jasmine was? Was she with you in the room or was she somewhere else?
Was Jasmine in the room?
Yes.
No, she wasn't. She was standing right there. By the door, like if she knew he was chasing her.
By the front door?
Yes.
Okay.
Right there where I said she was right there in the hallway. And she did state that yes, she doesn't know why she came to my house. She should have went where she always goes to her brother's.
No objection, non-responsive, Judge.
Sustained.
So just ask a question and the answer is regarding the question. You're adding additional information again. That's why the objections are getting sustained, ma'am. Okay. Okay, so I'm going to ask you about this door, okay? So the door, is it common that you're going to keep it locked, right?
Yeah, I'm gonna keep it up.
And obviously it was locked on this occasion, correct?
The kick door there.
Okay. Again, you have to answer my questions, okay? You're adding additional information.
Oh, Lord Jesus, you're.
So the door, it's common for you to keep it locked, correct? Is that a yes, ma'am?
Yes.
The door on this occasion was locked, correct?
Yes.
Okay. The pictures we looked at, you indicated that the dent was, from your understanding, from the kick,
Yeah.
correct? Okay. But then you mentioned that there was a lot of damage that was already pre-existing, correct? I'm sorry?
Yes.
Okay. And that damage, I mean, there was no splintering of the door frame. Would you agree with that? You just got to say yes for the reporter.
Yes.
Okay, thank you. There was no, like the lock itself was not like dislodged, correct?
No.
Okay. The lock itself was not dented or bent. You would agree with that?
The door what?
The lock itself?
No, it wasn't because they were just replaced.
Okay, so they were strong. They were new locks. Okay. In the 911 call you made, there was mention about neighbors having cameras. Do you recall saying that? Okay. And is that like next door neighbors across the street? Like who are you referring to specifically?
Across the street.
Across the street. And are you aware of any video that was ever obtained, or did you ever see any video yourself?
No.
Okay. I want to turn to the affidavit. So you did provide an affidavit at some point, correct?
Yeah.
Okay. In that affidavit, you were stating that it was you misunderstood essentially what happened. Is that fair?
That is from an AI that she copied and pasted from AI to send it to me tomorrow.
Okay. So my question was, in the affidavit,
This section is critical because this is where the case truly turns. What you're hearing now is a formal recitation of probation violations, and each one carries weight. Burglary of a habitation alone is serious, but when you stack that with repeated drug test failures, unfinished community service, and continued criminal behavior, it paints a picture of systemic noncompliance. Courts don't look at these individually, they look at the pattern. And that pattern is what prosecutors rely on when they ask for maximum sentencing. This isn't about one bad day. It's about consistent disregard for court orders. When probation conditions are violated this many times, judges often conclude that supervision has failed. That's why the phrase, "you could be looking at 10 years," isn't dramatic. It's procedural reality. At this stage, revocation isn't punishment. It's the court admitting that rehabilitation under supervision is no longer working.
essentially what you were saying is that you misunderstood what was going on.
Yeah.
Okay. Isn't it true that your daughter was the one who actually opened the door?
Negative.
Isn't it true?
My daughter didn't even buy the door.
Isn't it true that a few weeks after Alonzo was arrested and was in jail, that you, on Jasmine's phone, spoke to Alonzo? Isn't that true?
Yeah, because she passed me the phone.
She passed you the
phone that I didn't want nothing to do with it.
She passed you the phone, and isn't it true that you apologized to Alonzo
I apologized to him. What am I apologizing to him for?
for getting him arrested?
What am I going to do? He needs to apologize.
Did you apologize to him or not?
No, I didn't.
Okay. What exactly did you tell him?
That I didn't want nothing to do with the case.
Okay. Is that all you told him?
That's all I said.
Allowed him to go to state ISF and gave him specific instructions that upon release, he's released. And what does he do? He fails to submit to UAs multiple times. He's commingling with his mother when he's not supposed to. He's having this nonchalant, lackadaisical attitude with the field visit officer. He's possessing many liquor bottles. He's having a shrine of Santa Muerte. And moreover, he's committing additional offenses. He's hanging out with two guys that have firearms that they're pointing at a house and two children. He has displayed to this court many times that he does not intend to rehabilitate himself or be a productive member of society. And I would like to add that Ms. Almaraz testified that he wasn't submitting because he didn't have a ride and he didn't have money, but I take issue with that, and that he was able to find a ride to go to Nelson Avenue, and when he was arrested,
There's someone at the door.
he was in possession of $1,100. And he admitted to Ms. Griffith that he does not have legal employment. For those reasons, Judge, we're asking that you sentence him to the 10 years.
Judge, we respect the court's ruling. I think the court can see why we did choose to contest the burden of habitation charge. But we do respect the court's.
Now we enter one of the most delicate parts of any courtroom case: credibility. The defense is methodically pointing out inconsistencies, not to be cruel, but to test reliability. When a witness introduces new details that weren't mentioned to police or detectives at the time of the incident, it raises questions, not necessarily about lying, but about accuracy under stress. This is why objections keep being sustained. Courtroom testimony isn't storytelling, it's precision. Every added detail that wasn't previously documented becomes a vulnerability. Jurors and judges are trained to notice when narratives evolve. And while trauma can absolutely affect memory, the legal system still demands consistency. This moment matters because credibility directly impacts how much weight the court gives to the alleged sequence of events. And right now, the defense is successfully highlighting those cracks.
The court has the ability to do a few different things here. My client is still on deferred adjudication, or was on deferred adjudication. You could revoke his deferred adjudication and place him on regular community supervision with an underlying term all the way up to 10 years. I would ask the court to take some mercy on Alonzo. He is a young man who, from a young age, has been part of the system. And in this situation, Judge, I think Alonzo made a lapse of judgment, totally his own lapse of judgment, in pursuing Jasmine to that home. I think that much is clear. He should never have done that. But regarding what happens next to him, I think sentencing him up to 10 years, Judge, for a felon possession charge is too much, quite honestly. He was on for a third-degree felony. This is his first, that was his first adult case. And so if you are going to sentence him to prison, Judge, we would ask that you sentence him to the lower end of the range of punishment. But again, we are asking for the mercy, if you, given the felony conviction, to continue him on with regular probation.
All right, thank you.
Thank you, Judge.
All right.
I'm sorry, I just have one more thing. Because the predicate felony was a felony conviction out of Lee County. I believe that was his first adult felony conviction. But anyway, this court has given him mercy before. He's a danger to our community, and we're asking you for 10 years.
So, Mr. Taylor, when you were first placed on probation in this court, I realized that you were very young. The state was silent on their application, on your application for deferred adjudication. But I gave him deferred because he was very young. And I do believe the other matter may have been a juvenile matter that he ended up going to what previously was known as TYC. That's why it was a felon in possession or unlawfully carrying of a weapon by a felon. So I placed him on deferred adjudication. And I tried to give him conditions that would hopefully help him get his life in order. And then we came back on another motion to revoke. And I realized that there were some issues, and I tried to address those issues by setting certain conditions to address those issues. And so I am going to, I don't think there's anything else I can do for him. There's no other condition that I can give for him. So what the court is going to do, the court is going to grant the motion. The court will find him guilty. The court will revoke. The court will give him credit for any time served. The court will give him credit for any time served for the successful completion of ISF or any other inpatient treatment, which is dictated by law. The court is going to order that there's to be no residing in any households with minors. There's to be no contact with Jasmine Uribe. There is a $1,500 fine, time and money to run concurrent, and the court will sentence him to 10 years in the prison. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?